Hello, my name is Jingo Nelly, and today we are going to be looking at another tutorial. But before I begin off, make sure you subscribe to the channel. It will bring you some good luck in your forthcoming exams.
Hello, people. I was meant to give you the last audio on the last part that we did not complete, which is where I now believe that we are at par as to the processes we have to go through in incorporation of the company, and what we get at the end of the incorporation. And we agreed that after you have paid registration fees, you should get a certificate of incorporation, and thereafter commence business. Please note that public companies do not just need the certificate of incorporation, but also on top of that, they need a certificate of trading before they begin operations. Kindly read those up to the end and up to the change of name. Of course, change of name is very short. What you need to know is that for anything, basically, for anything that you want to change in the structure or the being of the company, you need a special resolution. Special resolution, I told you, it's that resolution that requires a special majority of members present in a meeting where the decision of the company is going to be made. Now, once we have agreed, once we have got to the point of certificate of incorporation and the company is good to go, we want to understand what happens thereafter. What is the net effect of getting a certificate of incorporation? But now we know the reasons why we do incorporate companies. We know why we should opt for uh, registration of companies rather than trading in our personal names. So we are saying, what is the net effect of incorporation? And the net effect of incorporation breeds or gives birth to the concept of corporate personality. I've said it time and again, and also in the explanation or in the definition of a company, that it is a separate entity which has a legal, personality. It's a legal entity which is fictitious, and it is set apart from the people who form it. Now, the locus, or the leading case which gives birth to corporate personality. Why it's called corporate personality is because corporate comes from corporation. Corporate personality. That means the personality of this company is only corporate. It is not natural. The opposite would be natural personality. Now this one is corporate. The personality of this company is conferred to it by corporation. So corporate personality is what distinguishes a company from other forms of business organizations. Now the locus class, the case that you must all read, and the leading case in corporate personality or in companies, is the case of Salmon versus Salmon. Do not please write your business law exam and forget to write that case. It does not matter where you put it. Even if you miss it, just put it anywhere so that so that at least you have it in there, because it's the locus classicus, like it's the leading case on this matter. Now you read the facts, but majorly from the facts you realize that Salmon had a business, and he converted the business into a limited liability company by forming Salmon and Company Limited. The company consisted Salmon, his wife, and 5 children as members. With Salmon as MD, shortly after the incorporation, the company experienced difficulties and it was wound up a year later. Because the company did not have enough assets to meet the creditors' demands, the creditors sued Salmon personally to recover their money. Now, on appeal, the court held that the company at law was a different person altogether from the subscribers, that the subscribers or members were not in any way liable to the acts of the company, save as is provided for in the law. Court further held. Now you read the other. When I say court held, that means the court decided as such. Where the memorandum of association is signed and registered, though there may be 7 shares taken, the subscribers are a body corporate. What you take from Salmon versus Salmon is that once a company is incorporated, it means that you have brought in limited liability. You have brought in an aspect of limited liability. Of course, and unlimited liability also extends to companies which even provide for unlimited liability, because the liability only accrues to the members, be it limited or unlimited company. The liability only accrues at the point of winding up. But once the company is still operational and is still a going concern, the issues of paying for people's debts does not arise. In other words, if a company has a debt from any individual, the first person to be asked or to be sued should be the company for recovery of that money. So it is only at that point where the company cannot pay its debts, or it's in the state of insolvency, where it's unable to pay all its creditors, that you say you can begin the process of winding up. And at that point, we now begin thinking about the issue of limited liability or unlimited liability or limited by guarantee, because at that point we now try to apportion the different scale of liability of the members for the company's debts. So kindly read the facts of Salmon versus Salmon and discuss them and try to understand the concept of corporate personality. Of course, I'll keep on describing it and we'll show it to you in discussing the effects or the legal implications of incorporation. Now, the legal implications are further manifested in the different formats. For instance, and the first one is direct liability of the company. And that one I've just discussed it, that once a company is incorporated and it is set apart from the people who formed it, by now you realize that where there is pre-incorporation contracts, the people who enter into those contracts prior to the incorporation of the company are personally liable for the debts that have been accrued. Now, once the company comes into existence, or once we incorporate the company, we are saying that the company then becomes directly liable for its debts. That's the first legal implication of incorporation, that you can no longer talk of pre-incorporation contracts, but you will talk of direct liability of the company. And they are giving you the only option as at the point of winding up. Now look at the case of Wani versus Uganda Timber Joiners, where at the case where the Indians had been chased from Uganda or banished from Uganda by the Amin government, and the court made a decision that, look, wherever you have a managing director, be it a director in the company, that person is only a managing director and does not take or does not cushion the debts of the company. He only acts as such, but cannot be liable to pay the debts of the company. Please read the case of Wani versus Uganda and Timber Joiners Limited. Then you have property ownership. This is very simple. Property ownership, because a company becomes a person, just like you and I. You own a phone, you own a car, you own land. The company has got the capacity to own land in its own names. For instance, if it's MTN Uganda, it can own MTN towers. It can own maybe the land, maybe the motor vehicles its employees use in its own right. Now, what we're saying is that the directors driving those cars, or once the director brings those cars in there, well, you will have bought it as a director, but once you register it in the company's names, that means it becomes a property of the company. You will read a very interesting case of Makaura versus Northern Assurance Company, where one of the founders of the company tried to insure the property of belonging to the company. And once he insured it in his names and the risk that was insured against occurred, he tried to recover from the insurance company. The insurance company declined to pay, and he took them on to court. Now, court decided in favor of the insurance company, saying the person or the director who had insured or who had taken out an insurance against the property did not have an insurable interest in that property, because the property did not belong to him but the company. Of course, it's a principle of insurance that for anyone to take out insurance from a company, he must have insurable interest. In other words, you should be able to lose anything if that property gets lost. So if you're an employee of MTN, do you suffer loss? You need to ask your questions. Do you suffer loss if a motor vehicle or the motor vehicle belonging to MTN crashes? Of course, if you're not in the car, for instance, what do you lose? Nothing, because it's not your car. MTN is the one that makes the laws. So it is in the best interest of MTN Uganda to insure the motor vehicles that belong to MTN Uganda. So an individual being a staff of MTN Uganda, and you think you're driving that motor vehicle for your for your work, and you go ahead to take out insurance, if in the unlikely event or in the likely event the car gets an accident, you cannot claim from the insurance company because you did not have insurable interest in the first place. So those are the first two. I want to break up these audios in two smaller portions. So I'm going to send another one shortly, talking of the other legal implications of corporate personality. Thank you. All right, now we continue with the next one, which is capacity to contract. Now, since we have said that a company is a legal personality, or it has a corporate personality, that means it's like you and I. For instance, especially if you're above 18, if you remember your law of contracts where you had capacity to contract. Now, capacity to contract is also envisioned in corporate personality. For instance, if a company is incorporated, then it gets the capacity to contract in its own names, first of all. That MTN Uganda or Airtel Uganda or MOBS can contract in its own names because it has the capacity to sue or be sued in the first place. Now, the leading case in this case is Lee versus Lee, and air farming, and that is a very wonderful case because it even gives you the worst, because in here Lee owned 90% of the shares, and he was an employee of the company at the same time. So he was drawing a salary from the company he formed. He's Lee, he forms a company which is set apart from him. He's an employee as a pilot. He draws salary from the company. The company pays him, much as he's the 90% shareholder. Once he's in it, he crashes while on duty, and the wife sues the company, which Lee had opened up, for compensation. Now the company says, you see, we cannot pay you because you and the company are one and the same, because you have 90% shares. The court says, look, this person was separate from Lee Farming and Company, the Lee and Lee Company. Lee is different from the company he formed, and he was rightly an employee. Therefore, it was very legal for Lee to contract with the company which he formed in an employee-employer relationship. Therefore, the court held that Lee could legally get compensation from the company. Now that shows you how different it is, that you can form this company, and then that company begins to pay you a salary. By now you saw it in the issue of promoters, you also see it in management, where a director can double as a shareholder. That's where we have people like executive directors and non-executive directors. Some of the directors might be shareholders, and while they're shareholders, they're also executive. They are working for the company, and as such, they are drawing a salary from the company. If a director is non-executive, perhaps, and is not working for the company, then he is getting dividends in that regard. Then the other one, we have capacity to borrow. I think the numbering is long. Capacity to borrow should be number 4. Of course, being a company, just like you and I, it can contract, it can borrow money in its own names. Then we go to perpetual succession. Perpetual succession means that a company can live in perpetuity. It cannot die off, just like individuals. When we die, everything of ours basically stops. You can now not act in my name. If Jude is deceased, then you say the late Jude. But for the company, once the directors who formed it all die, the company remains in existence. And that's what we call perpetual succession, that the company continues to live in perpetuity or perpetually, and it outlives the people who formed it. You can look at different companies which are very old. You can look at Mercedes-Benz, for instance, Toyota you can name it, Daimler and Chrysler. The people who formed these companies have long died, but the companies have continued to exist. However, what you should note is that the only way the company comes to an end is through the only way the company comes to an end is through the process called winding up. That the company's business has got to be wound up under a very clear process, which you will also cover at the end. So I don't want you to come up and say, you see, a company has got to live forever. Da, da, da. I need you to give me the exception of how a company can be brought to an end through a process called winding up. Then the last bit includes legal proceedings, that a company, after it has been incorporated and has got a legal personality, it can take up legal proceedings in its own names. And you can also take up legal proceedings against it in its own names. Now, for us as lawyers in our field, if a company, there are very many people in the field who use names and they look like companies. Someone just comes up and sets a name because he loves maybe the crane, and they say it's Crane Limited, and does not go to Uganda Registration Services Bureau to register that as a company and to have it registered or incorporated as a company. He only uses it as a name without incorporating. Now, in the future, that outfit can have challenges, legal challenges. Now, what you need to look out for before is, am I dealing with a company that is registered? You as business people, tomorrow you'll be in the management of different companies or as accountants. The first thing you need to look out for is that if I'm dealing with company A, is it indeed a registered company? That's why when we're looking at incorporation, memorandum of association, we said the memorandum of association should be looked out for in case you want to know the legal standing of a company or of any outfit which calls itself a company, because that way it will show you that this company has been incorporated, it's supposed to be trading in Kampala, it's a limited liability company, or it has the following shareholders and stuff. The other way you need to look at it is that, of course, you must look at the certificate of incorporation. Is it incorporated? Is it allowed to trade? That way you realize that this company has got the powers to sue and be sued. So you look at that. Then disadvantages of incorporation, please read it. It's very expensive. Some people cannot afford the charges. The company maybe could go for about 500,000, and maybe the process is complex. When they go to the lawyers, we charge them a bit. Some company which is not, maybe some people are not ready, do not readily have it because they are starting out businesses. So it might be expensive. Then the documentation is quite much. Then incorporation involves a number of formalities which are complicated. Then the cost of winding up, as you will see later, is a bit is quite long. Then I need you to read companies distinguished from other business entities. Please, once you answer, when I ask you about companies, please do not tell me about, let's say, corporation sole or NGOs as being companies. No, those are different outfits. They are not companies. An incorporated association, and personally, they do not have in themselves the other things that we've talked about. They cannot sue or be sued in their own names. They do not have the legal personality. They cannot own property in their names. Okay, for instance, if it is partnerships, you cannot own property in its own names. The property is owned in the names of the individual partners. So look at them: cooperative societies, public corporations. That now public corporations, they're a bit different from companies limited by guarantee, much as they also have a legal personality. For instance, if you look at statutory companies, statutory companies like National Water and stuff like that, they have a legal personality, but that legal personality is conferred onto it by statute. So they are statutory companies. So you look at that. Please, at this point, please compare notes with the other, what do you call it? The other notes, which are a bit lengthy. They will provide you with more options on this part. Please read on that part. Please compare with the other notes, which are a bit wide. Then we go to the concept of lifting the veil of incorporation. This is also a very important aspect in business law, lifting the veil of incorporation. What is a veil? We need to understand what is a veil of incorporation. What is a veil? A veil, for those of you who are maybe Catholics, or all of us know Catholics, you have nuns. It's a veil, that thing they cover themselves with on the hair, on the head, to cover the hair. The Muslims, our Muslim friends, they veil themselves. They do not, some of them, I don't know whether it's the tabligh or just the others, they veil their hair so that it cannot be seen. Now, once someone has a veil, we are unable to see what is on the inside of the veil. And we're saying that a corporate entity veils the people that are within the company. The corporate entity, once a company has been formed and set apart from the people who form it, you get a certificate of incorporation. That certificate of incorporation, in essence, veils the people who are inside of it. Once the certificate of incorporation is given, what we see of the company are not promoters, are not shareholders, but the name of the company. That you have, maybe, I don't know, City Tires Limited. Many of us might not know the directors behind City Tires Limited, or do we even care who the directors are? All we need are services. So whenever we need the service, we know we are dealing with City Tires Limited, because there is a veil of incorporation. That veil is hiding the shareholders, the directors, the shareholding, how many shares do each one of them have, how many people are employed by the company. We do not care about that. All we need is the service. Now, of course, when you're contracting, like I've told you, sometimes you need to go deep inside to establish who am I dealing with. Now, of course, we have already talked about the case of Salmon versus Salmon, which provided for that creation of corporate personality and the veil of incorporation of, it does not matter if Salmon started with this company, that what is important is that once he started it, it became different and distinct from Salmon. So Salmon cannot be held liable for the debts that the company might enter. Now, read the case of Dunlop Nigerian Industries Limited versus Forward Nigerian Enterprise. Very good case. In this case, the High Court of Lagos stated that in particular circumstances where the device of incorporation is used for some illegal or improper purpose, the court may disregard the principle that the company is an independent legal entity and lift the veil of corporate identity so that it is proved that a person used a company he controls as a clock. A clock is also, I think, that the kings put on, the kings wear. That's a clock. For an improper transaction, he may be personally liable to a third party. What they're saying, that if it is found out that the company, that these people used this veil, this sham, or this fictitious individual to deal improperly with the public, then the court will be at liberty to lift the veil of incorporation and look inside and say, look, wait a minute, you call yourself City Tires, but the things you were doing were not meant for City Tires. Or you say you're using City Tires as a company to transact in gold, but City Tires as a company was registered to transact maybe in tires alone. So the company, that means that, and if it did that and it wronged third parties, the court is at liberty to lift the veil of incorporation and look inside and say, who is in here? What are they exactly doing inside here? So that they protect. Basically, lifting the veil of incorporation is meant to protect the innocent third parties from being duped by individuals who run these companies. Are we together? It is meant to protect the innocent third parties from being duped, or from being cheated, or from being unfairly treated by individuals who run these companies. Now, lifting the veil of incorporation is looked at in two broad categories. That is the statutory lifting of the veil and case law lifting of the veil. In other words, by statute, it means that the statutes or the laws or the acts provide for instances where they can lift the veil of incorporation. And in other instances, case law has provided for it. If you remember in our introduction to law, in the law of contract and stuff, or in the introduction, you realize that statute law leads and after case law leads. In other words, where the statutes have fallen short, case law has come in to provide for alternatives. Most times, case law now has been incorporated in the new act, for instance, in the new Companies Act, where initially the lifting of the veil was provided for under the case laws. Now, statutory lifting of the veil instances is the first instance is where the numbers of members falls below the legal minimum. Now we know the legal minimum. If it's a private company, 1 member. If it is a single member company, if it's a public company, the list number is 2 members. I see 7 there, and private, please amend accordingly. So we are saying if the law is provided for that you must not have less than 2 directors and you trade with just 1 director for 6 months, that means if you got into a debt around that time, that debt cannot be put onto the company, but you people must pay it as individuals. Therefore, the liability is put directly onto the people who are trading with this company during that time when the membership fell below the legal minimum. That's the effect, and that's the purpose of the law. Then number 2, where the company is not mentioned in the bill of exchange. By now you know the bill of exchange, checks, promissory notes. Now they're saying that for any check, now you see the law, I think it's the law these days, the banks, if it's a check, it has got to have the name of the company. Now it envisages where you have a promissory note, for instance. But if, God forbid, if there is no check, the check does not mention the name of the company, and you write on behalf of the company, and you borrow or you pay out someone on behalf of the company, and the name is not reflected, the law is saying that they will lift the veil of incorporation and look for you personally. They will not put liability on the company, but they will put the liability on the individual who signed the bill of exchange. I hope we are following each other. Then the third option is holding. First of all, before I go to the third, what the principle behind going for that third party is that the individuals might use it as a trick. They give you a check which does not have a name. Later, when you come for the company says, we don't know that person. When you go for the person, you say, I was working on behalf of the company. So they leave you in between. So now the law is saying, look, if you do it, we are not going to look for the company, we are going to look for you as an individual. Then the third instance is holding and subsidiary companies. We are saying we use the veil of incorporation to understand whether company X is a holding company in company C, which is a subsidiary company. If there is a subsidiary company, then we also lift the veil of incorporation to see who owns the majority shares, who has the controlling force, who has the management of this company. That way we tell which one is the holding company. Are we together? That's another way. So in other words, why you need to look, what you should know is that the general rule is that once a company has been formed, we do not have to look inside its operations. No, we just look at it and that's it. But we're saying that there are those instances where we need to look at the management, where we need to look at the actions of this company, where we need to look at who is managing, who is working behind this company. And those are instances where we have lifting the veil of incorporation. Then number 4 is where there is reckless and fraudulent trading. Please read that. Reckless and fraudulent trading. That's very natural that when there is fraud cannot be committed by a company because the company cannot think on its own. The company is thought for by the people who are called directors or the shareholding per se. So if the directors have been involved in fraudulent actions using the company as a cloak or as a sham to take out money from individuals, then you have to lift the veil of incorporation for these people to be exposed. Then number 5, taxation. Taxation, you know now that under the Income Tax Act, I don't know if you know it, but under the Income Tax Act, when you're taxing companies, you tax them differently. For instance, if it's the corporation tax, you tax them differently. Or if it is the directors, you tax them differently. So sometimes you have to look at, to open the veil of incorporation and look at how much is the director getting. Is the company, first of all, a Ugandan company? How does it become a Ugandan company? It depends on the majority shareholding and the directorship of the company. Was it registered here? Was it incorporated in Uganda? You have to look at all those. You do not get that information unless you have opened or you have cracked open the veil of incorporation. Number 6, investigation into related companies. It almost looks like the issue of holding and subsidiary companies. Kindly read it. Then lifting the veil under case law. The first option is where the company acts as an agent of shareholders. Read FG films. Then where there has been fraud or improper conduct. Pretty much like I told you, case law has been incorporated into our statutes. So it is also being provided for in the statutes and also in case law. Look at these cases. Please read these cases. They'll give you a better insight. And remember, lifting of the veil of incorporation is a very big component, is a very important component in company law, and yet very easy. What you need to appreciate is that certificate or incorporating a company veils all the people who started it. So we do not know, we do not look inside. Now, that's the general rule. Like we said, law is a subject of exceptions. Now, we look at the exceptions under what circumstances would we look inside? If it is this person who is dressed up well, do we know if his boxers are in tatters? Do we know if his boxers are torn? Okay, so we say, how do we know? Let him remove the trousers. Then that's when we can tell whether the boxers are torn, whether the boxers are fine. Now, the improper conduct of the people who are dealing with companies are the torn boxers. Are we together? And we are establishing, we're like, at the top of it, things look normal, but the inside is rotten. So that's what we are trying to establish in this. Then public interest. Some companies, you read the case of Daimler Company Limited, where you have to trading with the enemy. For instance, recently, where you had an issue with Rwanda, and the Rwanda border was closed. So if that means if you trade with Rwanda at that point, or Rwanda, the companies in Rwanda traded with Uganda, it means they would be, in essence, be trading almost with an enemy, because if I've closed the borders and you continue trading here, it means that you're trading with the enemy. Now, they're saying in public policy, because for any decision that is made and they're saying we are closing the borders, it means it's for the benefit of the public that the borders are closed. Now, if you continue to trade with the people whose borders were closed, it means you're trading with the enemy of the state. So under public policy, that way you have to open. How do we know? Companies, when you read the case of Daimler Company Limited, you realize that the issue was in determining whether the company, having had many German nationals, made the company local or German. And they're saying since there were many German directors, the company was in essence a German company. So the court said, you know what? It does not look at whether the issue was, the basis was deemed the company, and the investigation was conducted to bid to satisfy public policy of not working with the enemy. So you have to lift the veil of incorporation to determine that. Then lastly, in determining the residence of the company for tax purposes, you read that. How do you determine the residence of the company? By looking at the residence, first of all, of the directors. Where are they residing? So if you're talking about all the directors being resident in Uganda, then definitely that company is a Ugandan company. Of course, why we look at that is that foreign companies pay different tax, and local companies pay different tax, different levels of tax. So in essence, it is very important for us to establish whether a company is local or not, and we can only do that by lifting the veil of incorporation. Now, with that, you permit me, I think I have satisfactorily discussed the introduction to this subject. and I believe you have understood. Kindly discuss with your colleagues. These things are very simple, and do not try to spot, because everything is examinable, and read for purposes of understanding. Once you understand the subject, once you understand these concepts, you will have no trouble understanding the subject. So I wish you well, and I hope the other people take you through well. Thank you.
Thank you so much for watching. Make sure you subscribe to the channel.